Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Don't miss the fun. Meet Baker and friends, it's second to
Welcome back, everyone. New update from the case we just left. They won't be allowed to use the defense of other defense. So this guy is up a certain creek with or without a paddle, because he just admitted it to the defense that he did it. And it's not a defense in South Carolina to go to someone else's establishment who he doesn't know when the kid isn't home and do it. That's what the judge have ruled. So I don't know where they're going to go with the defense. Could be they don't even put on a defense. I don't know. Because he won't be allowed to talk about that stuff. So I have to say it again. I don't feel that the defense really did good in that case. Sorry, I'm just updating the socials that we switched over to this because some people might not know it. No, but it's really, really it's out there now. So again, what defense would you then turn to after that one? Because he admitted he did that. Are you gonna go back and say, "Well, I didn't do it. I wasn't at the house. It's not me on the bike." You have to have a Danish face to sit there now and when you're cross-examined and they say, "Don't you own that bike? Doesn't look like mine." Do you own a black hoodie? Nope. I only have a maroon hoodie. And that day I had a very bad leg cramp, so I couldn't ride my bike at all. And my stabulator hand, I got some arthritis in my shoulder. And technically, yeah. Realistically, I can't see what defense they're going to swing with now. Because they are not, yeah, thank you. I got it from you. They don't have anyone to disprove the DNA. Yeah, he said he did it in a defense of the little girl. He went to her house, stabulated her to defend the little girl. Not in front of the jury, in a pretrial or in a hearing before the jury arrived. But again, now everyone, and apparently the courtroom is filled today. So I know technicalities. I know, well, actually, but in reality, what are you gonna do? They can't bring it in. No, well, they can't. But still, what defense are they gonna put on? They don't have a DNA expert to disprove the DNA. It is his DNA. It was him. So, still, I would have shut the hell up and said, wasn't me. Well, oh yeah, I sold her a bag of Coke. She must have, it's transfer DNA from the bag of Coke. Probably a better defense than saying nothing. I just can't see what defense they're going to put on. Pin massage.
What up?
Hey.
Goodness. All right, I'm better.
He did it in before the jury was there, so they were arguing the defense that he wanted to use the defense that he was doing a public service and saving the little girl. And the judge said, that's not a form of defense we recognize in South Carolina, so...
Yeah, he's not in a good spot now, is he?
He... unless they can have someone come in and contest the DNA evidence, which is the only part linking him to the scene. He is what I think is called oct in English.
Yeah. Ukidfe in Pig Latin.
Bigly.
Bigly. Bigly indeed.
Well, he can't talk about the CP, so he where's he going to get the sympathy? That's a problem.
I think that was probably his plan. I think the defense was really, really counting on that CP getting in. And
they were looking at that fastball coming down and just hitting it out on that one thing.
Yeah.
Because they were hoping the CP could come in. So, yeah. Can't he say that he did it to save the girl and not say why, just hint at it? No, I'll just read verbatim, so it's not my word, it's Pretty Lies and Alibis saying... Judge says he understands the defense argument, but it's not South Carolina law. He went to someone's house he didn't know and unalived her. The child wasn't home. It defeats any argument of defense of others. Defense argues more saying Zach went there with the sole purpose of protecting the child. Judge has gone back into chambers. But I don't see him changing his mind because he has been gatekeeping the CP a lot.
Hard. Super hard. I don't know.
What do we expect from today, Valhalla?
Motions, like a lot of them, right? Like a couple hundred motions got put in or something insane.
I think it's like 14 or 17 or something like that.
14, couple hundred, same thing. She's not going to rule on any of them.
No.
She has to. No.
She's gonna retire and do her thing. Yeah. Have some White Claws roll a dice.
Have some little intern out there write up her decisions for her.
And again, we have been here before where we're gonna do motions today, and then 10 minutes later we were hostile taco. See you later.
Yeah,
because she never. Yeah, I've read your affidavits.
Yeah. She doesn't want as much of it out loud as she can help, I don't think. I think she wants to keep as much of it hush-hush.
Yeah. They can't bring in the CP. They haven't been able to bring it in the entire trial, so I can't see how they can use it as a mitigation as well. Maybe the judge will use it because he knows about it, but I don't know.
Doubt it. if he didn't want the jury to know about it, he's probably going to try to not keep that. You know what I mean?
Did you feel the same way that the tone kind of shifted in the new motions?
I actually haven't looked at them. If I'm being
I just
completely
feel
honest.
like the defense have been more combative. They have always been kind of, oh, let's keep it civil, let's do it the right way. I feel like the last bunch of affidavits and motions have been very combative
Good.
because Brennan kind of was a douche canoe to them, and now he wants
Kinda.
sanctions brought against them. That's interesting.
That would probably explain why they're getting a little more combative.
Yeah.
If Brennan's
Well, it was before that, but
if he's asking for sanctions, though, I mean that's
it's
a different level.
most likely because they brought a piece of a transcript of Proctor's text messages to Adam Lally, where he wrote, "I skipped watching the closings, sitting here all anxious or something, and I didn't skip it because I couldn't listen to it, but I couldn't listen to that asshole Alan Jackson or something like that." So they put that in a motion.
Outstanding.
So and maybe that was, I don't know if it was under orders or something that they couldn't use it, but yeah, it just again shows the highly biased nature of the police department. And that man was sequestered. Why was he? Why was he watching the trial?
Yeah, good question. Good question.
Gonna just keep patting the swear jar just because it's going to be needed for this trial. It will.
It definitely will. Aaron Olivia became a member. Thanks, Aaron. You've been a member for a long time.
She's been there for a long time, hasn't she? She must have re-upped.
Yeah.
How's
God,
she doing?
this is
Haven't talked to you in a hot second.
It's been like 3 days. We we talked just like 3 days ago.
No.
Yeah, what day was the Ronnie on with Turtle Boy? We talked that day.
We texted. I asked you if you want to join. We haven't. had.
Oh, you mean like on YouTube, like in
We haven't.
face-to-face?
No, we haven't talked. We just talked for 5 seconds. You said I could stay at your digs if I wanted to, and that's kind of what we've talked since Friday prior.
Yeah, we
hang
were
out
talking
anymore,
briefly
man.
about got things going on, I guess.
Yeah, you're busy.
Yeah, goats and whatnot.
How's the
They're getting
kiddos?
huge. They're getting huge. The chunky one, he is so big. I actually might be able to pull the thing up real quick.
I don't have memory of a goldfish. I'm pretty good at remembering stuff. Did you tell each other you love him? No, I don't use that kind of language.
I do. I tell everybody I love them.
Unless I have paid for it, I don't love them.
When I get off the phone, when I'm on the phone with people and I'm talking to them, I don't say bye. I say love. That's my like sign off. Love.
Yeah, well, you're a lovey-dovey person, not like me. I'm a cold-hearted Scandinavian.
Well,
Still haven't bought my tickets. I sitting yesterday doing it because this other no, it was President's Day yesterday. Happy Ben Franklin's Day, and I had just punched in the travel thingy to find the tickets. And they called me from court and said, "Hey, someone just called in sick. Can you come?" I said, "Yeah, sure." Came up there, was there for 10 minutes, went home again, and then I got out of the rhythm.
That sucks. How?
That'd be nice. No goat body shaming. No, like fat goat is a great goat.
We like fat goats. We want all the goats chunkers.
The bakery is Scandinavian like a child pretends superhero. Text to speak is not always accurate.
It's never accurate.
But it's did you watch? No, you didn't watch the interview with her either. Then
No. I haven't really paid attention to much. Why is the lighting so weird?
that's a pretty good interview where they all of the lawyers work for free for her. All of them are donating their time. That's
I heard
that's
you say that
impressive.
earlier. That's amazing.
Now, I thought it was only Alessi and Betterow who did it, but apparently all three of them, the original, also does it for free.
That's
And,
how you know you believe in your client.
Yeah, and they it feels like they're swinging away from the third party culprit. Know that it didn't work that well, so
The Turtle Boy interview was actually really beneficial in that. I thought Ronnie being able to kind of share what the jury was going through, albeit
yeah,
making me a
and
little
what
sad.
they. Yeah, but it's because we watch everything. We watch all these pre-trial motions. We read everything. We discuss it with each other, and
117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Is that loud enough for everybody? Sounds quiet in my headphones.
Good morning, Mr. Brennan.
this is what I can
Good
do.
morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little,
Okay.
also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Miss Reed.
Good morning, Mr. Alessi. Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Sidebar to begin with. Yay! Betterow wouldn't be in court today, at least not now, because he hasn't been approved to go pro hoc vice. So he's not a part of the defense team officially yet. Yeah,
Yeah,
they're gonna need a
seriously.
bigger table.
It was scary to learn what the jurors' thoughts were.
But I've said it.
But I understand
1,000
your
times.
point.
It's not about facts, it's about feelings. Benjamin Frank, legendary, please go back and watch my real video about how Washington was a Swedish guy who cheated him out of his recognition.
Stop lying to the people. Ben Franklin was never a president. Stop it. You're gonna have all these Europeans confused. Good morning, Donna.
He built the White House, the first house in America with electricity. The reason why it's white is so you could better see illuminating. It's just facts, Valhalla. I didn't take you for a Washington night.
Washingtonite.
Yeah.
Is that like a Canaanite?
No, it's like a QAnon person. Believing
QAnon.
going down the rabbit holes and coming out with a ferret instead of a rabbit.
Oh, I've gone down the rabbit hole, sir.
Why is he on a $100 bill and not on the G-string filler, the $1 bill? I'm just saying.
Probably to commemorate his
All right, so
contribution to this great land, even though he was never president. That would be my guess.
what I'd like
They
to
gave him the
do
big bills.
is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass court. So Commonwealth's motion for
That was quick.
records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Morning.
I spoke to Mr. Albano last week and again last night,
Okay.
and on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk. All right.
And again, there's nothing in it.
Next,
It's just the interview
I
we
did
saw.
amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right, so paper number 483, this is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
She can't deny it, right? Like, how could she?
You shouldn't, but you could just hit.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument, and you can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Let's go, Mr. Jackson.
I'll take a
Thank
quick
you, Your
bio.
Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we did not need, we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to
That
believe
video
at the time.
disappeared, y'all. Oh my
So we
God.
asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well.
Hey,
And that's
Money
the
G.
key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have
Really
it.
filed it
We're
'cause
entitled to it. It's
Commonwealth
simple.
is
That's all
being
we're
a
asking
dick.
for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense.
I'm not even sure why
If you
this
want original
requires
files,
argument,
get it from
given the
defense. Knowing
video.
full well that we don't have it. If we had
They
it, it
should.
wouldn't be
It's a
there.
Brady violation if they don't.
Right. This is
And
insane.
then that,
Give
it
them
was
the
that
video.
same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those
now
same
there.
data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations.
Why would there be video 3 years after? Because it's your job to preserve the effing video. If I hate this guy.
It's an ongoing case. It's not like this went away for a long time and reappeared, right?
Yeah,
this has been a constant investigation into this case, into these people. That video should have been preserved day one. This is common sense law stuff.
And again, Why did you find it 3 years later, you big idiot?
Interesting.
That weren't accurate. I no longer have the confidence to have off-the-record agreements with the defense. There
Oh,
has to be a certain level of confidence that when you have an agreement and you try to help the other side,
He's taking his
that
ball and he's going
delivery
home.
of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and
Oh, I hate him
always
more than
honor the
Larry.
court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to.
they were entitled to have the video, you idiot. It's not like you are entitled to withhold evidence in a murder case.
Did he really just say the defense wasn't entitled to evidence?
Yeah, they weren't entitled to come and see if there's more video on the DVR system. They are when you keep drip dropping videos constantly. Why haven't you turned over the metadata?
I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download...
If it still survives.
If it still
There's a motion 3 days after to keep every single piece of footage that could have anything to do with this case. I can't do this.
Download it. He then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information.
He just did. His name is sounds like an Italian dish.
That he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later, so we were happy to do it. And then when we got back to the office, the request changed Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked.
Now the only delay is them making. You don't give them the metadata. That's the problem. You can have. We know I mean the Commonwealth. You cheated in the first trial, inverted a video, and now they say we need metadata on everything. And now they're just lying. There's no cover up. There's no. Oh, he's an idiot.
Them playing the inverted video in the last trial and denying metadata now is super fishy. I don't know if anybody else is tracking on that, but that's pretty questionable to say the least.
That simple click and drag also inverted the image and cut out a chunk of the file,
Exactly.
you silly. Yeah, and you can't
Exactly.
go in and say, was there ever those 40 minutes, because you don't have the metadata to show that this is 12:05 and this is 12:45. So where's the 40 minutes?
If they happen to find
Accommodations and-
who's the one cop, the Homeland Security guy, the guy that was drunk and then went to work at 1 a.m.
Brian Higgins?
Brian Higgins. If they find Brian Higgins on that video after he testified that he wasn't there at all,
Well, they did find him. That's why they're asking for it, because he claimed he didn't have a phone call, but he's seen talking on a phone at the Canton Police Department. That's
saw
why they
somebody
want
break
the full
that.
download.
I saw somebody break that video down. There's some suspicious activity in that video, y'all.
We haven't seen that video.
Well, I have.
Then
I
because
think I have. I saw somebody breaking down a video.
are you thinking about the Sallyport video? Maybe.
Yeah, in the cell.
Yeah, that's not the same. He is at the police station. Remember, he went back to do administrative work,
Yeah.
which is moving 2 cars around.
Yeah, had to move 2 cars around while he was intoxicated. Yeah, I remember
Yeah, and that's when he's seen on the phone. And then the next day, when they take her car, he claims he wasn't at the garage, and then he was at the garage. So that's 2 different videos. We haven't seen the one where he's talking on the phone.
Okay.
And yes, we also have outside cameras we haven't seen.
different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or
Alan
argument.
Jackson's ready.
Yeah.
How quickly can you do that?
I imagine we could do it one day, but today it'll be done by the end of the week.
You want to make, I'll be heard briefly,
Yes,
very, very briefly.
take your
Pissed.
time.
Thank you.
Oh, take your time. What
Mr.
the?
Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of the trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the...
October 24th,
Fourth.
did that video come with the metadata?
Nope.
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, and again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. This is metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact,
Then give it to him.
historically, if we
Yeah,
look back,
just turn it over.
To come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
You're obligated to provide it.
Yeah.
Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last
Go
time what
Mark.
you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
So Pedro's still not allowed in.
Crazy, right?
Well,
Thank you, Your Honor.
I don't know.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes, yes.
Is he gonna argue against Betterow?
So I did just say unless there was an opposition. Is this an opposition?
Yes.
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing.
Yeah, he's now arguing that she can obtain the defense counsel she wants. That's got to
They
be
just said
interesting.
it wasn't in opposition though, so I'm curious how this is gonna go.
Yeah, I just don't like him, Your Honor.
Yeah, this isn't opposition because he's clearly unqualified
Yeah,
for
I
the
don't
position
recall
anyway.
that.
So
Yeah,
Dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr.
Boy.
Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case.
Abso-effing-lutely not. He has never been found guilty in that.
Those were all
and
dismissed.
And you tried to bring Karen Reed in a grand jury. Well, you didn't, but you are the face of the Commonwealth. Bingo. You tried to bring a conspiracy grand jury in to say that they conspired to harass witnesses. You're just making stuff up constantly.
The speed limit is 75, but the traffic in front of me is slow, so I'm doing 69. Thanks, Zach. Appreciate it, buddy.
Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow
Indictments are not.
is representing him for.
Remember, y'all, this is the land
It's
where
not
you're
great
innocent
clarity,
until
but
proven
it's been
guilty.
represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is
Allegedly, I allegedly have been harassed by you. I never brought any charges because I don't feel it, but allegedly someone thought that you harassed me. That's not the same as you did it, because you would never do that, Mr. Brennan. You are such an outstanding guy. Now that someone has been charged is the same as them being guilty. I know you are a sleazeball who does this for 75K. Well, at least you have earned more than double that so far. This is the worst argument, and he does it without blinking. It shows you why he's a good defense lawyer, but a really bad prosecutor.
It's curious that that relationship exists, and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review.
Aren't all those
of
protective
discovery,
orders done now?
and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage, and I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive.
Yeah.
We know it is
If this piece of
deep
paper won't
relationship.
work, then nothing will.
The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate,
He's a journalist. He can call whoever he will. He's a civilian. He can call whoever he will. Karen Reed can call me tonight, and we can talk about the weather. It doesn't mean anything. That doesn't mean that I can't do what I do. I could have a conversation with her and say, well, I'm really interested. Can I do an interview? And she can say, yeah, just like Boston 25. Because I am technically a journalist, because I cover news and stuff. What does it mean that she and Kearney have had more than 30 phone calls over a 3-year period? We know from Michael Proctor, it doesn't mean anything. Him and his sister called each other 6 to 8 times a day.
Weird, bro.
but having a mutual agreement.
You can see
a
how
mutual
much they
aid
absolutely
agreement
hate
does
Turtle
not
Boy, though.
allow an attorney then to
Yeah,
can't
because they're
stand
afraid of him.
who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant
So Betterow
is
Betterow should be off because
to a fair trial.
they haven't been
He's entitled
harassed.
to another attorney, so I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
I like turtles.
Okay.
Holy shit, pause it.
Misty and Ed.
Is that EDB on that screen right there?
Yeah.
Outstanding.
Aiden is watching EDB in court.
Oh, that is Aiden, ain't it? He's sitting right there, dude,
Misty
talking
and Eddie, I
shit.
have to consider everything that was just said.
Oh, that's
I'll
amazing.
wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay.
He's such a
The next
troll.
one, I believe, is paper 489.
Did you hear Kurt wanted him thrown in prison because he, the last trial he put up, remember Clay, his fantasy baby with the fake victim? Kurt spurred out and, oh, he should be in prison or something like that. And I was like, come on now, that kid never existed. So relax, buddy. Ugh. Thank you, Jemima, for. I'm pretty sure I've sworn a lot in chat. I think everyone is kind of swearing beneath their breaths.
Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you. Mr. Bowman.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay. There's no objection to this, is there?
No, Your Honor.
Of course, I'll provide that copy for.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at One Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from Attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at One Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, and today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first, or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses, and that's what we're asking the court to reconsider. It is our position, Judge, that part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure, from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. You know, if we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but you know, this is I won't say unique trial, but it's a rare trial that, you know, it's streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought you meant 2 points that you made both do.
Understood.
All right, so, Mr. Brennan?
Hash marks aren't hashtags, nor are they hash browns. Always with the good points.
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice.
Hey, Boosh.
A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations.
Right.
And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I
The
get
defense is
random
obligated to
emails
produce
from
everything,
unknown
but the
people,
prosecution, not
sometimes
so
their
much.
names on them,
Come on, bro.
talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control, I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they are going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it will be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best,
Nope.
and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent.
Shut up, you a-hole. It happened constantly during this trial. You own it. You're the face of it now. You represent the Commonwealth. Everything Lally did, you did. It doesn't matter that, well, I'm new to the trial.
This guy gets up there. First, he argues how the state isn't obligated to give the defense metadata about the videos. Then he gets up and he argues that the defense is obligated to give the state every little piece of evidence that they have access to, which may or may not be the case. I'm not entirely sure. And now when they're like, yeah, you've been doing that the whole time, he's like, I'm so sorry. It wasn't my intention, and that's a horrible thing. Like, this guy will say literally anything. Anything.
If they in the next second say, well, they dumped all the evidence 2 weeks before, so we had it. Yeah, I might try to drip it out so they don't get overwhelmed. So I'll just leave it at the door every morning. Just this guy will argue anything opposite, and he just argued that there's no obligation to turn over metadata, which there is. And now he's saying the defense should turn over everything so they don't do ambush by trial. You put in an averted video.
This dude should not be in a position of power, period. He should never be in a position of power.
No. Can you put his underhand? I never played before. Yeah, that's...
All
right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth, paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that's still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course, Your Honor. For those, I'll just ask that the court allow those requests. For request
She's
one,
gotten
Your
a lot
Honor,
more
we've asked for
confident
all
since
chain
this
of
whole
custody
thing started.
logs, reports, evidence logs, and other documentation
Good for you,
regarding
girl.
how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to
Look how
material and relevant.
Alessi just put up his tablet so she could see something he wrote on it. It's
he's pretty smart.
That's a good thing. Having the iPad Pro. No, not. What did Bev just said? She said, "You want them to write a report? No, they should have a report."
Relevant evidence.
They should absolutely have a chain of
They
custody.
don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There are certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of...
Well, the evidence is allowed because it's the judge who determines if it can be let in without a chain of custody, and this is Bev.
MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes, and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages that corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore, no evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right, if somebody can
She probably doesn't know that she signed that order herself.
tell us the paper number so we can find that.
Thank you, Your Honor, I will. The Commonwealth has indicated that they do not
Probably
object
not.
to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case.
She's going for it, ain't she?
We find the Commonwealth's response to this request.
I said it earlier today. Gloves off. It's let's fight. It seems like they are very, very, very thin on patience, and I don't think it helped that Brennan stood up there and claimed they lied.
Probably not. All that dudes motivate him a little bit. That's probably why they're doing this for free now too. This is like a personal situation for most of these lawyers. They're recruiting badasses from all over the place.
Yeah, in fact, her voice has gotten way better. She must have, maybe she, I don't know if she had done a lot of trial work before. Maybe she went back and listened to it and said, okay, I need to assert myself a little bit more when I speak. But it helps that she's fired up, I think.
Objecting to it, particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right, Mr. Brennan.
Turtle Boy will get it, so we can't give it to them.
It's important to represent facts accurately.
Shut up.
And the court has ordered in the past, and representations have been made that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense...
Why doesn't it exist? It's incumbent upon the Massachusetts State Police and the Canton Police Department to keep records. I hate this guy. We don't have the evidence because we don't want to do our job. So, who? It could be Brennan who downloaded it. It could be the cleaning lady. It could be the magical video fairy. Who cares? It's just they got the video. Come on now.
How are you supposed to substantiate any piece of evidence without a log, a chain of custody? Like it seems absolutely asinine that wouldn't exist. It doesn't make sense.
You need the right judge, and then you can do it. But what we are seeing here is a guy who says, "F it." I bet you, if he was on the other side and someone came in and threw down a CD and said, "Yeah, we found this evidence." Where? Oh, it's in the mailbox this morning. He would probably fight twice as hard to keep it out. Jesus.
An informal discovery request, I would look into any chain of custody information. And I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot...
No, but then you have a big problem, because then you shouldn't use the evidence when you can't prove who obtained it, when it was obtained, who downloaded it to make sure that it's downloaded correctly and hasn't been tampered with.
Who may or may not have altered it or flipped the video or deleted minutes of somebody appearing in said video. This dude's crazy. This dude
chain of custody that is not
I hate this guy.
There is no witness to.
I thought I hated Lally, but it was just his stupid way of asking questions. This guy is lying constantly and completely bullshitting all the time. I hate this guy.
He reminds me of Gravely and Binger. He's that caliber of prosecutor.
Yeah, it's just I'm just gonna lie until it sticks.
Yep.
my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out
You're out of
those
your mind,
words
bro.
for our audience.
If you think cops covering up a child sex ring and a murder of an innocent woman isn't relevant to the current situation, you're out of your mind.
Scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to.
It's the same people.
We are a little behind. So Turtle Boy already shared the evidence that extracted by Trooper Nick Guarino, performed by Trooper Guarino, analyzed both of these phones and did not find any communication with Sarah Birchmore. Matt had said in a previous interview that he deleted all communications. Yeah, but the feds did it, you big idiot. The Birchmore trial is just as bad as this one. Police work way, I don't know what word I'm trying to find, but you're defending the people who raped and unalived Sandra Birchmore and the cops who covered it up. Way to go. If I didn't hate you before.
In the discovery motion, there must be a factual basis for it. A factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report.
I just showed it.
Nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience.
She's such an idiot.
And so the reality is the Birchmore case is being investigated by federal authorities.
Can he be sanctioned for lying to the judge?
By the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case?
Because all the idiot cops from this case is in that case as well. And
that case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing.
That your technical guy, the guy who looked at the technical evidence, didn't find 10,000 communications between Sandra Birchmore and the guy who unalived her, allegedly. That could have something to do with this case, you idiot. He admitted on the stand that he overlooked 10,000 communications.
But invoking it is helpful for the defense, so they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense, so we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, that most recently set out in McFarland and Graham, The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant material, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth versus Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition, to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor. To the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference
argue against ARCA.
Between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text messages between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week. And I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right, so I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
I can
over
keep that.
500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan?
How are they possibly going to argue against
Sure.
this?
They can't figure out who hired them or something. His argument is stupid.
Your Honor, my purpose is not to deprive the defense of an expert.
Shut up.
But I'm gonna.
Shut up. Just don't start with that. Your Honor, it's not an argument against Mr. Betterow, but I'm just going to do a 20-minute speech about why you shouldn't allow Mr. Betterow. It's not to deprive them of an expert, but here's why you should deprive them of an expert.
Or deprive
hate him so
the
much.
defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
You have the discovery.
You
You
have
both
everything.
got the report from the feds, you idiot.
It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. it's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination.
You know what? I agree. Actually, I agree. I think, in fact, that they should be allowed to tell them exactly who they are and why they're there and how they got there.
Yeah.
I completely agree with what you're saying right now for the first time ever. They should be absolutely allowed to tell everybody that they were hired by the Department of Justice.
We are not hired by the insurance company. We are hired by the Federal Investigative Bureau of Investigations, because there was this case and it looked really shady, and they asked us to test this. This is why we did what we did. We built a cannon and tested the polycarbonate tail light. Yes, we are here by orders of the feds. We are not hired by the defense. We're not hired by the state. We are hired by the federal government.
I completely agree with what he's saying so far.
Yeah.
Of adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now,
they weren't allowed to do it.
I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed in over a long period of time with requests and deadlines. I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
You just stated earlier that you, after watching the last trial, so again, you're a little bit pregnant, you never watched the trial, and you did watch the trial.
A little bit pregnant.
So there is email correspondence between
Schrodinger's
the
womb.
defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with the retainers required. Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now,
So he didn't give them monetary compensation because the federal government said you can't talk to him, which is totally cromulent what was represented in court.
It's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination.
That's why he's not
Commonwealth
getting
did not have the
information
luxury.
because the
Federal
federal
did not even
government
know
is
that there was an outline that was being disseminated.
holding back information from the potentially corrupt department, correct? That's my assumption anyway. My assumption is the FBI or the Justice Department or whoever made it so that they can't give information to the Massachusetts State Police and the Norfolk County and blah, 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 because they're all under investigation, right?
The TUI investigation is keeping it under wraps because, yes, there's a federal investigation into the police department. And the ARCA guys was brought in to affirm or disprove the theory that Karen Reed hit the car, to kind of look into the bad practices, I think. We don't know what actually is in the report because it's secret.
And he has to know that, right?
Yeah, but it doesn't matter because he can use it to say that, well, we can't get the information, neither can the defense, but clearly see this email where he talked about monetary compensation, he lied to you, Your Honor. No, because the answer was, we can't talk to you. This is what the messages said. And then I got you my CV. Yeah, that was by order of Bev. She said, give it to us. And that's what he stated. We prepared for the trial, talking about their education. Again, he's lying about everything. I'm sorry to say that. He's a lying liar who lies.
By this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting.
There's no real accounting. You just argued that you can't provide accounting because it doesn't exist. I hate this guy. I hate him.
I hate him so much.
I hate this guy. Lally was an idiot. Lally was stupid and annoying. This guy is smart enough to know he's fucking lying all the time. Sorry.
I've never seen somebody this capable of switching his stance. Like this is unreal. He can stand up and argue one point, and the next immediate breath argue the exact opposite stance. It's impressive.
Oh, it was a different motion, so just that he had the
It doesn't
totally
count.
opposite position on that motion isn't the same. Thank you, Stephen. I forgot the rules of Brennan.
Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over.
This dude should
a lot
never
less
be in a position
this
of
case
authority
than
ever.
this.
Do your witness have any bias? F it, he's an idiot. Swear to your front.
Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever.
I don't think I've ever heard you drop the F word. Shame on you, Baker. Shame. I'm sorry, Lefty. I know it's a good Christian channel and it hurts your ears, but thank you so much.
Cleared up. And then a bill from Marca to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. To create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the witnesses testify at trial. I don't care about their opinions.
Clearly
but I
you do.
care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome Marca.
All right, I'm going to take a recess before the response.
All right, please.
He's out of his mind.
He's absolutely crazy, yes. Thank you, Lefty.
That was good.
This is worse than I imagined. It's
He's basically saying because ARCA proves that it couldn't have happened and has to take the side of science, they shouldn't be allowed to testify. That's basically what his last little bit there was.
Yeah, because
they're biased because physics proves that they should be.
Yeah, and they mentioned a wrong number of trial dates, and they got $3,000 from the defense. Yeah, they probably got way more from the federal government.
Way
and
more.
Again, you want them to put in reports about the communications with them, but you don't have to do that for any of you. You want an openness about the witnesses that the state is going to bring, but all your evidence is just hunky-dory that no one can prove when, where, or what it is. But he's just annoying. He's just annoying. Marissa, could you jump on, and then I can go make myself some dinner because this is taking longer than, and it's 6:30 my time. Marissa said she would help. Why do I always feel like he's going to have a 2-year-old tantrum all the time? Because he sounds like it's the same argument, but Mom, they did it. Hey, little D. And thank you so much, Holly Mack, for 10 memberships to Laurie Wallace, Lynn Goff, Ariel, Jesse, J. Cass, Volstom. Haven't seen him for a while. Stace, Annie, get your pew pew. Christina always, and Sarah D.
You got quiet when you were looking down away from your mic.
I turned our volume way down as well, so.
It's impressive. It's impressive that you can switch like that.
It's so stupid. I can see you. I pulled you up before. Well, yeah, you don't know that. You think it's Valhalla who pulled you up. It was me. I did it. It was me all
He's
along,
got control.
Austin.
I can't even pull up chats in here. It's weird.
No. Do you know who can pull up chats?
Marissa. Hey, girl. Hey.
Hello. Oh.
What's your take on this? Oh, we're behind, by the way.
I can't hear. Hold on 1 second.
She gone.
Bye.
She's got the wrong audio hooked up somewhere.
Yeah. She came on and said, "Oh, it's these two clowns. I'm leaving."
You didn't tell me Valhalla was going to be here. God.
Thank you so much, Holly. Can you hear us now?
Yes.
Outstanding.
Sorry.
Good.
So what do you think?
Hey, Stace.
I've got to tone down my cursing. It's bad.
I pulled the
disgrace.
cord if you want to put it up.
Mm-hmm.
Yeah, it's actually the way he's arguing. A is correct. You could never do A. B is correct. You can never do B. He's constantly disproving his own arguments in the motions before, and then he watched the trial. Then he didn't watch the trial, and I have experience and I know kind of something about federal cases. Yeah, because you defended a big federal case that you lost.
Yeah.
So,
what was that case?
The Whitey Bulger. He was a defense lawyer for Whitey Bulger, and
wow.
they claimed the only reason he needed a defense lawyer was to prove that he wasn't a snitch. That didn't work.
That didn't work at all.
He
was a snitch.
Well,
just saying.
I'm just saying that his defense lawyer wasn't that good because he paid for it the second he got into the clink.
Yeah. Yeah.
If I ever commit a crime in Canton, I want this guy's defense lawyer. Not only is now buddy with the state, but he's also shameless as you want your defense lawyer to be. Yeah, this guy, he's a private dancer, a dancer for money. Can't be faulted for losing defending Whitey Bulger. No, but when the only thing he really wanted to make sure was put out there was that he wasn't a snitch and he got stabulated the first day in prison because he was a snitch, then probably didn't do that effectively in court. But
he didn't really do a whole lot, sounds like.
But weird. Do you think she has some irritable bowel syndrome or something? Because that was I'm going to take recess.
Oh,
Who,
yeah.
Marissa? Nah, I think she's okay.
No, I'm pretty sure Bev had to go take a poo.
That morning coffee hitting just right.
Or she's pounding a White Claw.
That
she was getting the shakes.
Or having a smoke with Lally.
Head starting to hurt a little too much.
Yeah.
But I really don't think she likes Brennan.
She might not.
You can clearly hear she's not talking to him like a small child, like they did with Lally. It's for clerks. They're union based. We've been going for an hour and a half. Normally they'll go for like 3 hours.
Yeah.
She's slamming the claw. She has to watch her figure, so she's on the claw lights.
Yeah. Is there anything lighter than the White Claw?
Water.
Zima.
Zima is all
Light?
sugar.
Is it?
I thought so.
I don't know.
I think they still make them.
Mama's boy. She pretty much helped Lally along. Like,
Yeah, she was holding her hand, but this guy, it seemed more like she's, what the hell's going on? And
Well,
she
that's
talks to
the
him kind
thing.
of like she talks to Alan Jackson.
Well, that was the thing, though, right? With Lally, he wasn't being definitive about much of his reasoning, so she could help him through. This guy's just like, oh, this is wrong and this is why. So she's not really getting the opportunity to hold his hand. He's making it hard on himself. Bringing Zima back. I remember drinking those when I was in high school.
I'm so old I can remember when we got California coolers and they came and people thought, oh, it's going to be the new thing, and then I never saw them again. It was like
Never
one
heard of it.
summer, all the moms started drinking California coolers. It's kind of a spitzer with white wine in it, I think.
Okay.
like Arbor Mist.
Right.
I don't know what that is, but
Pretty much that.
Yeah, it's a wine cooler. Yeah, but I think with a little bit of carbonation in it. Yes, I'm only 27. My mom had some hidden.
He's just been 27 for a long time, That's all.
Then we got breezes. Yeah, I don't mind a breezer in the summer.
You know what I really enjoy in the summer? The summer shandies, the lemonade and the beer.
I hate shandies.
Do you really?
I'm not a lemon guy.
I love a shandy.
Peter doesn't like
I love a
food.
shandy. That's true.
He eats like shrimps on toast.
With cheese. Ugh.
That's it.
I'm gonna bring some shrimp cheese. So all of y'all. Oh, we're gonna eat some Vegemite. I'll give you some shrimp cheese.
Shrimp cheese brought over a 2-day journey from Denmark. Can't wait. Can't wait. It's going to be yummy.
Yeah.
26 hours last time. Come on, that's not that long. And maybe someone will try and open it like they did with my Lord in the airport.
Ooh. Nothing screams fresh like 26-hour-old shrimp cheese.
Well, there's so
Yeah,
much
right?
salt in it; it can't really go bad. Yeah, I like a good apple cider or pear cider is actually better.
Pear cider?
I understand that Brennan is taking umbrage at the defense comments, etc. It may not be how he would have acted in the first trial, but this is what happened, and he should stop taking it so personal. No, I don't think he even knows what happened and why the defense is so angry right now, because I still don't think him and Lally have ever spoken together.
No, he just holds his pencils.
Yeah, he's just sitting there for 5 hours.
You think Lally's salty because he got demoted?
No, because apparently the reason they had Brennan is because no prosecutor wanted to take it to the second trial. So
It
Lally
shouldn't have been
didn't
brought
want
to
to
the
retrial
second.
it.
Shouldn't have been brought.
I think Lally's salty because he has to sit there all through it anyway. He was hoping to get out of it.
At least give him the
further
cock chair in the
embarrassed.
corner so he's not on camera all the time.
I know. With his
It's,
hands between his legs.
Put him next to Paul O'Keefe so we can see 2 sets of balls.
I don't want to do that. I don't want to do that at all.
I don't want to think about Lally having balls.
I don't think they're that big.
They're underdeveloped for sure. Let's be real.
Lally is a hostage. That's the truth.
Oh.
So is poor whatever her name, McLaughlin or whatever her name is.
Yeah, she never said a word. Never ever said a word during the first trial. Totally agree. I don't think Brennan has any idea about the first trial. No, and I think he's one of those guys who'll just yell.
How could you not though? Especially being in that prosecutor's office. Like, how could you not know that it was this bad?
But he's
the
not a
Sandra
prosecutor.
Birchmore case is happening, and the Karen Reed case is happening.
He's not a prosecutor. He's a ringer. They brought him in to only do this case, so he's not part of any of it, and he will only have the information they give him. And when he doesn't do his research, then how should he know?
Mm-hmm.
And I really don't think he knows anything about the trial.
I think he does. I think he has to.
I think he's playing
No,
dumb.
because his argument about the chain of custody, and well, I can't just I'll go back and get it. There's none. They testified
Right,
to it
you
in
can't
court that
make
they
it
have
up.
no chain of custody. So if they find chain of custody, all of a sudden again, that's another Brady violation.
But he doesn't. He
It's-
just doesn't want to admit it. Like that's the only thing he can say is, "I'm going to go try to find it," or "I'm going to go get it."
Right.
Because if he says we have it, why didn't you bring it? And if he says, "Well, I'll go," if he says it doesn't exist, that's
Chaff
Then
also
why
and
a
doesn't it
problem.
exist?
Chaff and redirect.
Mm-hmm.
And again, you have
Smoke
the
and
things
mirrors.
he stated about the Birchmore trial is just patently untrue.
Right.
Him? Yeah.
It made no sense what he was saying, that there's no overlap. There's like 5 officers that's overlapping this, and one of them is the main tech guy in this case, who has
Who couldn't
proven
find-
he shouldn't ever be hired to do any phone extractions again. in both cases. So,
Right.
and he has. Oh, that's a fun little experiment. How many cops testified in the first case? Well, Brian Higgins, he's a DEA agent or something, so he doesn't really count. Then you have Trooper Guarino, who was working for the DA's office. He's been moved. You have Proctor, who is on leave without
Suspension.
pay.
Yeah.
You have Bukaki, who got reprimanded. You have the other guy who also had was it Trooper Paul or who was it who also lost vacation days? All the officers who testified in the first case more or less have been sanctioned after.
And Fanning was in charge of the jury.
Yeah, but again, you can say what he couldn't because he's not in the room with the jury. But you have that juror who was removed the last day because someone saw her at the waterfall bar. That was very sus. I think that witness should have been in there testifying, and the bartender or whoever. Why was she just removed? Brian Tolley was a part of this as well. Michael Lang, I think, was the lead detective in the Birdsmore trial.
He was involved in this.
Yeah, so...
wasn't he the first one on scene, Lang? Was
yes,
Good
in this
involved?
case. In this case, in the Karen Reed case. But in the Birdsmore, I think he was the lead detective. But...
Link, right?
Yeah, Lank. Because Lank was the one they called back to get Jen McCabe's testimony when she all of a sudden remembered after talking to Brian Higgins what was said.
And she went to Lank's house.
We watched how many cases now on my channel? 50, 40, something.
A lot.
The only other case where the police have been this bad is the Treehouse murder case out of Florida, where the lead detective had mistakes in 17 out of 18 cases and was now a 911 operator or something like that.
How do you go from a lead detective to a 911 dispatch operator? Yikes.
Well, that's the only future Proctor has, and maybe not even that.
I wouldn't.
Proctor. Well, that's another thing. Why hasn't Proctor? It's just a disciplinary action.
Oh, because they don't want it to end before this, because then they can give all of that discovery.
Yeah,
that's a complete stall.
And if he's found to have acted in a certain way, they can bring it up because the state won't be calling him. They claimed, well, the defense sure as shit will be calling him. And then you have, why haven't Aidan Carney gone to court yet for his case?
So that they can keep claiming that he's harassing and intimidating witnesses.
Stalling.
It's we're gonna keep the Democrats sword over you all the time, so we can all of a sudden just chop it in half.
I think they're waiting for Mello to croak on that one.
Yeah, but
because then they can't call.
Yeah, maybe that's why they're doing it. They lack sway in the department. That's yeah. That's
It takes a lot of effort to knock SLED off the worst law enforcement list, but I think Massachusetts state troopers pulled it off. I think they got him. Congratulations, SLED. You're now the number 2 worst law enforcement department in the country.
Well, this was indoors, so that was different. That's Experience, well, the mindset in the room is not what we think. No, because we immerse ourselves in every little motion, in every little hearing. We read Aidan. Some of you watch you watch the good streamers at night when I'm sleeping, and then you come back and tell stupid little me, "Hey, did you hear that the Clara said this yesterday? Mike had this person on. I just watched Melanie Little, and she." And then I'm sitting here saying, "Oh, interesting." So we have all of this. It's kind of like the Zachary Hughes case. We know all about the kitty stuff. We know all about that. The jury doesn't. So we can't understand why they don't feel the same way as us. But it's because they are sitting bored to tears in a courtroom that's probably stuffy, hot. Half of them are half asleep. I had it one day in court where we were doing some financial stuff, and it was just putting in evidence that just have to be in for the record. So we were just trolling to one report, another report, and we didn't have any, you don't take notes or anything because it wasn't important. I had to, in the end, I sat with a pen and just stabbed myself in the leg to not fall asleep. Because you get so bored because you can't, as a jury, you don't do anything. It's not like I can take my phone up and play with it or bring a squishy or something. You just have to sit there for 8 hours a day.
Yeah, I don't think I could do it. Although apparently I have to next month.
That a girl.
I got called in by the federal jury. Oh, we've got movement.
I'll go and make myself some dinner then.
Wait, how do I?
You
Present it.
remember to embiggen it.
Full screen. There you go.
All right. So the Commonwealth just provided the court with
I don't hear nothing.
information that causes me grave
We can hear you.
concern. The implications
Why
of
can't I
that
hear it?
information may have profound effects on this defense and defense counsel.
What?
So for that reason, I'm
What'd
going
she
to
say?
suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
What just
So I'll
happened?
see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
I don't know. I can't hear it.
She said something about profound impact on the defense.
And where
Something was
Mr.
brought
Brennan,
to her
where the
to look at her
federal
shaking.
authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with?
I'm just taking you off, so
Get rid of the Nightbot comment, please.
All right. So the Commonwealth just provided the court with information that
was bugging
causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today
She's
at 11
shaking.
o'clock in the morning. You can tell me now if that is impossible for you.
It's like she ran.
She's like trembling right now.
something is bad. It's not just, well, Alan talked to Arca. No, this is something
I don't
else.
think so.
Reason I'm
I
going
think
to
somebody
suspend
just got arrested.
So
Something really bad
All right.
happened.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
The defense and defense counsel. So it's a lawyer who fucked up. A lawyer did something bad. No, she's not
Commonwealth
referencing
provided.
to what the state said in open court. She said she was just given information from the Commonwealth that can have profound impact on this defense and defense counsel. So
for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
it's not what was provided in court, I think.
So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
That has been provided to her before this.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief.
So she got something from the federal government.
Uh-huh.
Maybe they made an arrest.
I think so. I think somebody got arrested. I think Proctor or possibly
No,
Morrissey.
listen to what she said. Defense counsel. The defense counsel is the people sitting
Provided.
at the table. Proctor wouldn't change anything
No. And he's already.
on the defense counsel. It has nothing to do with any of the other players. This has to do with the defense counsel.
Chronology, I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you. We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Thank you.
Aiden is writing, Bev came back from break clearly upset by something and no one in court seems to have any idea what it is, but I'm guessing something about the Fed investigation, which all parties admitted today is ongoing. Did she say that the Commonwealth presented the insurance? He wanted to make sure the defense was prepared. Yeah, something she's good. She's someone on the. It right now it looked like someone on the defense effed up.
Okay. All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today, or no?
No.
Okay,
All right, 11 o'clock on the 25th.
thank you.
All rise for the court, please.
Someone, no, he gave her an email he got from the defense. So it's not him playing dirty. If she read it and and believes it implies foul play by the defense in such a way that it could impact the defense and the defense counsel, that sounds like someone is gonna. Can she chuck someone off the defense team?
I mean, I guess she could.
I don't know. You don't believe it?
Yeah, they don't look rattled, but they're
No,
lawyers.
but they wouldn't look rattled even if you pulled a gun on them. This is their job. There's a reason why Alan Jackson wants to be there in person. There's probably going to be a fight over something. It could be the payments to them, but if they're not employed by the feds anymore, he should be perfectly okay by paying them to come in and talk to him. But then it could be that he didn't provide a report for talking to them. I don't know.
I don't know. I agree with Island. I'm not sure that it necessarily means the defense messed up.
Well, clearly something happened. If she says
clearly something.
It's it could impact the defense and the defense counsel. She could revoke his pro hoc. Jackson said he paid them, but say he didn't. It's not enough to pay $3,000 to flip like this.
Yeah.
Well, it's never a good impact if she suspends court and says it has an impact on the defense and the defense counsel.
Lefty.
So, yeah, I'll call Grant in a minute. It's going to depend on when the payments happened and why. Yeah, and if he misstated and said, I never paid them a dime.
But I don't think that would be enough to...
No. But why do we have to point the finger at the defense? We have to point the finger at the defense because she clearly stated this could have an impact on the defense and defense counsel. I'm not throwing shade at them and saying they effed up. I'm just speculating why she said. You heard it. I didn't make it up that it was, according to her, the defense side that had effed up. It's not. I didn't just make it up and say, well, she clearly was given emails that pertain to communications either with the feds or with the ARCA guys that was provided to her from the defense that made her so angry she canceled the meeting today and claimed that it could have repercussions from for the defense and defense counsel. Is she going to chuck the ARCA guys out? She can't do that.
I can't imagine how she could.
It's I don't.
Profound impact. Yeah,
She didn't say detrimental. She said profound. Like it doesn't necessarily.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So it's not on this case, it's on the defense. Again, that's why I am casting shade on the defense, because she clearly states it's the defense. That something came up that could harm the defense. She also have to protect Karen Reed. If shady things are going on. So that's the thing.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
Yeah, maybe it was in a good way. Who knows?
Oh, that wasn't in a good way.
Leave.
It might be. That might be why she's so upset
She
about
might
it.
not be excited
No,
about it.
try listening
Yeah.
to what she asks when he walks down.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
So it's the emails he got from Lally that she wants a copy of today before he leaves. I don't know. I could
I
only
think it
be.
could go either way, because if they just provided something because they knew they were going to be found out or something, I don't know.
And again, she wouldn't do this if I can't see her. The way she has treated the defense, she wouldn't do this if it was pro-defense. Then it would be dropped in the middle of the night.
There was two parts to the information. It sounded like to me. There's a piece of information provided by the federal government, and then a piece of information not provided by the federal government.
No, that's because she thought it was from the feds, but he then states that he had gotten this communication, ongoing communication, through February, and that he had gotten it from the defense. I can go back and play it all because.
The emails between Jackson and Arca about their education and such? What do you mean, Jess?
Yes, we filed
To see if I can, in fact, get a copy of everything that you just read. And federal authorities, and where Mr. Brennan, where the federal authorities have been kind enough in the past.
I'll just go back so we can hear it.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can, in fact, get a copy of everything that you just read?
I can.
So everything he just read was the money paid to ARCA. The Fed said you can't talk to us, and the notes if they wanted to change something, and the other side might want to question us about this. That's the thing he brought up from the communications between Adam Jackson and the ARCAS. Alan. Yeah, sorry. I'm a little rattled.
And there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts, and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government.
So she's asking to the emails provided by to defense?
Defense, February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it?
From this outline is then the outline with remarks from this B, again, to forward an engagement letter to this email. In deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests.
So now he claims this isn't provided by the defense, but he said he's going to say later it was provided by the defense.
And insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle, I had enough information from the material I reviewed, so it wasn't necessary, need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the...
This is what makes her take the recess.
I think he's reading things out of order.
He could be.
I think he's spinning a web of something.
If this is enough for her to demand sanctions and maybe take away pro hoc vice from Alan Jackson, why did she allow inverted videos in from the state then?
We're calling this equal.
Why did she not respond at any point to witnesses clearly changing their testimony on the stand? Why have she allowed Brennan to lie constantly? I don't know. And I don't know, I'm not a lawyer, I don't know if it's legal or illegal. So most things happen after June 22nd, email from what I can tell, and I think she allowed them to talk to them about this stuff. I think it's you don't want me to talk about it stuff, and that she's probably going with they are keeping things secret from the state or something like that. But when Brennan argued before, it was, well, that's for Cross to find out. So isn't it for Cross to find out? Because he got the emails, as I understood it, from the defense. So he knows all of this. So he can just prepare his cross-examination accordingly, saying, well, isn't it true that you communicated to the defense that you were willing to keep it secret that X and Y? You can use it in the cross to impeach their testimony. So I don't know. It's going to be very interesting.
I thought it was maybe something to do with the fact that they were paid, but if they ended their federal contract,
Yeah.
Alan Jackson isn't saying he didn't retain them for this trial. That was the
No.
last trial. So he very well could pay them.
Yeah, I know he said the information come from defense, but he lied and said it came from
Right.
the state. Some it was from March 24 before the first trial, and that may be, yeah, if it's before the trial. But if the part of it is, hey, I'm Alan Jackson, I want to talk to you about this case, and they say, yeah, sure, let's set it up. Oh, by the way, I can't talk to you. If that email is the one from March 2024, there's no cover on the ice, as we say in Denmark. But if should I change my testimony? Can you say this? Can you say that? Is from before the first trial, where he said I didn't have any contact with them. That could be a potential problem, but I don't think the ARCA guys, because they're pros as well, they wouldn't have inappropriate contact with a defense team.
No,
I can't see that.
No.
But
you'd have to believe that not only the defense team was being shady and going behind the back, but also ARCA, and that's kind of crazy.
Yeah, I think they're twisting it.
I think so.
Yeah, and again, because he gave them the timeline, so it's from March 2024 till February. And if all of the retaining stuff happens after the Fed, and why the Fed dropped them because they did give them the report they needed, and you don't keep people on retainer.
Right,
just,
the contract was complete.
Yeah, their contract is to look into this murder and then shut the hell up about it unless they are given the right to talk about it. And that ended with the first trial, I believe, was when maybe it's still in the TUI because there could be an ongoing federal investigation. We don't know, but again, if it's a Brennanism, but then why would she react this angrily? I don't see why she would, because she was shaking when she came back.
She was absolutely shaking.
Well, I think she might have just been out of breath from like running between chambers or something.
No, she was clearly.
I mean, she's a smoker.
She was trembling. Her hands were trembling. Everything she was holding was shaking like crazy.
Only part before June was the defense saying sent the engagement letter over, and then the USAG telling them no. Everything else was after June 22nd. Yeah. So, but again, what if anything? I don't know.
I agree. Somebody had said like this is probably going to be a huge nothing burger. I agree. Probably will be.
It could be, but it could also be her way of, because we know she's not playing fair, and she can use the excuse and say, well, clearly your defense team was trying to pull shenanigans, and I have to make sure that you get the best defense possible, and I don't want to have an ineffective counsel or blah, 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 blah. So she can help Karen Reed.
In comes Bettero. I don't know.
We didn't get a date for the payment. But again, it could be that that the defense put them up for the first trial because they called them, so they paid them travel and hotel. Could be.
Yeah.
I don't know.
I'm looking for like headlines. I'm looking for something big to have happened out there.
Yeah, nothing has leaked so far.
Yeah, I think it's something that Brennan said that got her.
$23,000 is kind of a lot of money.
To fly?
To fly two guys to testify for a day, 2 days, that's kind of a lot of money.
Meals, hotel.
$23,000, Marissa.
They get like $400 or $500 an hour, at least.
I think it's too low to be in a retainer.
Yeah.
I totally believe it could cost that much to fly last minute. Like because they probably didn't know when they were going to testify. So they had to buy the ticket maybe 2 days, maybe in advance. Last minute airline tickets are expensive.
Yeah, and
And
they
were
don't
coming
fly.
from Pittsburgh and Philadelphia. They're not flying economy. Yeah.
And again, let's say they are ready for. Just got the
Like when I fly for work, I won't sit in economy. I pay for business class and charge my client. You crazy?
Yeah, I'm flying a premium economy when I'm flying to the States as well, because that's the fancy stuff I can do. But if Valhalla would pay me to come, yeah, it would be business class as well.
Yeah, and they're not staying at the Super 8. You're right, Darcy. Yeah, they're probably paying for like the Westin or the Marriott Premier in Boston.
And then you have. They were on the 24th of June. And let's say, because the state, as I just got a clip from.
They were on the
Jemima.
24th, and this was an email on the 22nd.
Yeah.
Probably for travel.
And again, let's say they're not sure that they can be there that day or that day. Maybe they had to fly out twice or be on hold and taken away from other jobs. As we're not talking about cheap people to have on hold. Marissa, you know what experts cost when you want to hire them, and if you say, well, we need you to block out 3 days in your calendar.
Yeah.
They don't do it because they're nice guys.
You're not going to give them a discounted price.
Yeah. Yeah, it cost $12,000 for the guy who went up just to look at the video fees, the video thing.
Zach. Yeah.
It also seemed. Go ahead, sorry.
They would also have to pay ARCA, not those guys themselves, if they were taking them away from work that was there. And the business, I tell you, is not giving them a discount. They're going to, as if they had a solid packed day meeting 3 people in an hour and billing them an hour each.
Yeah, and I don't know. But again, we're just speculating because we don't know. We only know she said, "Can I get copies of what I just read?"
Or what you just read.
Yeah, what you just read. And she saw something in those papers that got her so, to me, angry. That's how I read her.
Something was going on.
I don't know.
I think that timeline was conflated a little bit because he said this isn't dated. Well,
yeah, and again, then if it's not dated, you can put it anywhere. The expert cost 2 pixie sticks, and he will travel himself if you give him that.
Not the little ones, the big ones.
The big ones, but then he'll pay his own travel.
With that much pixie sticks, he'll just run back and forth.
Yeah, I know there was, as he said, there was a retainer. I know. But again, I don't trust Brennan. And what's a retainer? Is it for 3 days to be ready to testify in court? Because you pay your expert witnesses. That's not shady. That's not. ARCA guys doesn't do it for free. Neither does Hank Brennan. He's been.
Is it weird? Sorry. Is it weird that she didn't let Alisi do his motion? Right? Like something was so impactful.
No, she just ended the day because something is really, really bad. And that's why I'm thinking someone must have really on the defense side. But what if anything? We don't know. It can be anything. We're just speculating because the last thing we heard was something about a contact that Brennan claimed was shady. That's all. We don't know. We don't know what she got mad over. It could be that the ARCA guy said, "Should I keep this out of my testimony?" Maybe she want to do a new.
I don't feel like they would get in trouble for that.
No, I don't know.
It shouldn't. I can't imagine she would be that irate about it, right? Like it.
No, for putting them on retainer. No, absolutely not.
That seems silly.
Because Dr. Russell got paid as well, and so did Scoribello, and everyone else get paid. Every cop who testified was on the government paycheck that day. So
Well,
it's
I mean,
not
we've
that
seen-
you're paying for an expert, but
Isn't
it
that
could be
generally speaking part of jury instructions? Like the judge tells the jury not to worry the fact that people got paid. Like, isn't that something I've heard like a bajillion times watching court cases by now?
it's one of those shady things that they try and show that, oh, you got paid $500 to be here today. Yeah, I could have charged 1,000.
Right.
It's
For a judge to get that up in arms about it, I don't think that was what it was.
Yeah.
Doesn't make sense.
No, it really doesn't. And for a week to prepare for something, so you can speculate for another week. What I see on the Twitch thread is everyone is saying, "What the f is going on?" From Runkle to the fake Grant Smith Ellis, everyone is sitting here saying, "What's happening?"
Yeah, nobody
Christina
knows.
Rex, I asked Alan Jackson outside of court if he paid ARCA expert to testify at trial number 1. No, of course not, he said. In court, prosecutor Hank Brennan read documents including an alleged bill from ARCA to the defense for $23,925. That's getting duped, he told the judge.
So the question was, did you pay him to testify? And I guess he didn't pay him to testify. He paid him to travel, though.
Yeah.
It could be a...
and again, it wasn't dated. We don't know what...
Paid.
Yeah, also,
It's
it could have been...
reimbursing.
He might not have paid him by then, right? Like at the time, that might have been a true statement, and then billed and paid later. Something doesn't feel right about this whole thing. Something feels weird.
I really don't...
Ted Daniels is saying something. Prior to Judge Cannoni canceling the hearing, Special Prosecutor Hank Brennan said in open court that Reed's defense team communicated with ARCA about their testimony prior to Reed's first trial. Brennan read from what appeared to be emails between the defense and ARCA referenced a $23,000, I think he meant $2,300 bill. He says ARCA sent to the defense. Brennan called it unfair, imbalanced, and hidden in open court. I don't think that he gave a date on that, though.
There was no date. He said it's not
He
dated.
said there was no date. He said there was no date.
Oh,
he
trust
said
me, Dunk
23,000.
thinks he knows what happens. Yeah, but Dunk still has me blocked, so I can't see all his
Still?
wonderful things. Yeah, well, I can find his account and go in and look, but he has me blocked, asshole.
Grant's saying that Alan had undisclosed contact with the experts.
It's not undisclosed because he provided it to the state.
Right. They talked about it in the last trial, right? They talked briefly, and then they realized they couldn't talk, so they stopped.
Yeah, and that's what he said too, that they had a contact before the first trial, and it was just about getting ready for trial, and that was allowed under the order. And then he went into all of this, but again, what's the timeline? I think you need a brief timeline, and then he gives us a timeline that's way, way, way not brief. And it'll be service rendered to ARCA for 23,000 is nothing. It's absolutely nothing. Go back and watch the AHJD case and see how much every expert in that case charged. They charged one of those alone for a day in court and doing the stuff they had to do was, some of them was closer to 100K for what they did. And one of them was just watching videos and claiming a guy was drunk because he played a drunk. I don't...
Wouldn't it be
sadly, we
weird-
can't call Betterow because...
I mean,
he's,
did he get that information from the defense or the
Yes.
federal government?
That's what he said.
He said, I got it from the defense. I said, I'm sorry, I said the state, but I got it from the defense. And then she said you got it from the defense. Can I get a copy of what you got from the state? And he said, this is from the defense. Doink is always the smartest guy in the room.
Yeah, I don't know.
Get some pixie sticks.
The Smurfs are all saying the defense is effed. Of course.
Well, right now it is. Melanie...
They've been saying the defense was effed since the beginning of the first trial.
Yeah. And Melanie believes that it's just shenanigans from the Commonwealth. I will take the position I'll take on everything. I don't know. It seems weird that she blew a gasket like that. Is it proof of anything? No. Is it proof that there was an improper contact with the defense and the ARCA guys? I haven't read the emails. I can't tell you. I can speculate here from here till the cows come home, but it doesn't help any of us because we'll just sit here and speculate, and you'll say, well, Brennan is a liar. The Smurf will say, well, Jackson is a liar. We'll have to wait a week to find out what this whole thing is about. According to Alan Jackson, he didn't break the law, didn't pay the ARCA guys for the first trial. I trust him. I don't think he would make a mistake.
No.
Not something
so
like that.
amateurish.
Right.
So
it's not like he told ARCA to say that about, like, I won't say that if you don't want me to. You know, like, I think he's spinning that a little.
Yeah.
To make it sound like, you know, Alan was telling him other things.
And again,
to say and not say, but
and you have Brennan lying again. It was turned over by I got it after I contacted the feds, and then by the way, I got it from the defense. I don't know. I don't know what's right.
She asked him to reach out to whoever he was talking to at the feds, though, right?
Yeah, who sent it over to you, and then he said, no, I got this from the defense. So that's why he changed it back. Maybe I can show you.
All right, please.
yeah, I agree, Jess. I think he muddied everything up, and I think it's going to turn out to be nothing.
Don't do this. No, that's not the one I want.
That's not even the right trial. What are you doing, man?
They switched to, but when I go into this trial, they switch to a different trial. I'll just find it.
Your Honor should be aware of, because I was curious about the change.
I have to fly on the 24th.
Ended, but and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave.
Not provided by the federal government.
Yeah.
Contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave.
So to me, that also clearly indicates that she believed that it was hidden from them by the defense. I think that's what I get from this, that she believed this happened, and the defense tried to hide it from them, because the way she said, so the evidence you got not by the federal government, can you provide it to me? So to me, it seems like he sold her that she got it from the feds, but Jemima wants the timeline again.
And Volpe Fox, if it was something muddied.
The chronology is December 4th. We sent another tour request, 2000.
Of everything that you just read.
I can't.
You were enough in the past. At 11 o'clock in the morning, you can tell me. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with?
So she's under the belief that he had gotten this
Mm-hmm.
from the feds, not the defense. This is clearly her belief right now. When she comes in, is angry in the courtroom, she believes the defense have lied to her and the Commonwealth.
Yes.
You can clearly hear that because this she's saying right now is, we can't trust the defense. I have to have your guy at the feds send this to me.
To see if I can in fact get a copy of everything that you just read.
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right.
She
11
wants to
o'clock a week
sit
from
down
today.
with all of this information and figure it the F out herself. That's what she wants to do. That's why she's like, everybody shut up. We're ending. I want to get to the bottom of it myself.
Yeah.
Why wouldn't she do that right now, though?
Yeah, why wouldn't she take half an hour and...
Because she
go
may
in?
need to get more information.
Who's she going to get it from?
He's got it. Yeah, he's supposed to provide the emails that he just read or whatever. Like, he's got it right in front of him.
I don't know. She's
the more
best.
I listen to it,
She
the
needs
more
a white claw.
the more I think she believed that the defense lied and kept this secret, and they got it from the feds.
Well, if you note the dates that he was mentioning, those were all within the last like 2 months, right? December, January of this last couple months. So I don't know how
where
that
they
could be.
They could retain the ARCA services because they were no longer employed by the feds.
Right. So I don't know what could possibly be relevant in that.
Other than them hiding it,
this upset about.
Other than she's believing they hid it from the state and her, and they had to go on a hunting trip to find it. I can't see anything. I think she misunderstood it, and especially the way she said everything you just read that the feds turned over. No, can you get me in contact? They have been nice enough to turn stuff over to me before. All of that was because he again misrepresented what he was handing to her.
Yeah. That was a maybe he wasn't expecting such a spectacle too about it. Yes, exactly. I think there's a lot that she needs to go back and review and
interesting.
It's the communication with ARCA that could be the problem because they were not allowed to really talk to them before the last trial. And if Jess got the timeline correct, the email about the voir dire and the personal injury was on the 22nd. The ARCA guys testified on the 24th. So it could be that Alan Jackson had communication and was prepping them for the defense. And I know everyone on the Commonwealth had done the same, but ARCA was a different thing because it was the feds and they weren't allowed to talk to it. That's the only other thing. Either she totally misunderstood where the evidence came from, or she feels Alan Jackson has misrepresented his contact with them. That's
and
all
somebody
I
had
can see.
mentioned earlier, like, why didn't the defense jump up and say anything? Because they didn't do anything wrong, and it isn't their place to. They can't just jump up and say objection in the middle of a motion hearing. Like,
No,
they have
it's
to be
motion
given
hearing,
their turn to speak, and she didn't give them that, so their time to speak is next week.
Yeah, April 1st. Well, that's the start. So jury selection. Last time jury selection took 1.5, 2.5 weeks.
I think I don't think that it's got much to do with that. I think it's something else. I think something happened on the break. She got information on the break from the Commonwealth. I do. I agree with Volpe and Paula B. Something else is going on. It doesn't make sense to me for her to be that upset, for her to cancel the rest of the motions, for her to act the way she did. Something's different.
I really, and again, everyone is speculating on social media.
We're all speculating.
Yeah, nobody knows.
Yeah.
None of us have any idea what the hell's going on.
No, and everyone will spend the rest of the day arguing that
Talking
this
about it.
is a clear sign that Alan Jackson is being tossed off. It's a clear sign that Brennan lied to the court. It's a clear sign that the apocalypse will start tomorrow. We don't know. All we do is speculate, and all I base all of my presumptions on are the way we just heard Bev talk. To me,
and
I
look
think
at the way. Sorry.
I think Brennan misrepresented, or she misunderstood where these emails came from.
So Brennan, before the break, he was arguing that he wanted to have the same information. He wanted to be able to talk to ARCA. And then after the break, he was like, I'm not going to reach out to them at all because that would change things now. So something happened there. Like something changed for his tone. But then again, he's like a psychopath and just switches shit up all the time anyway. So who fucking knows?
Yeah.
It's very frustrating. It's very frustrating.
Maybe keep an eye on TB's social media the rest of the day. He's the guy who has the closest connection to the Karen Reed team. I don't think they know what's going on either. The way
I don't
Alan
think
Jackson,
he's going to say anything.
No. But if I should trust anything coming out today, because there will be a whole heap metric
rumors,
crapload
speculations
being sent out there today by everyone who will clearly tell you that I just saw that, well, finally Alan Jackson was caught in lying to the court. He turned over these emails. People, that's why we have been back and watched it, 3 times, 4 times now, to try and find out what did she actually say. And to me, it seems like she was misguided in believing that this came directly from the feds, not from the defense.
If she had the opportunity to spank Alan Jackson on TV and on the internet, I think she would have taken it.
I think she would have to go back and look through everything before she started a public spanking, because nothing is better than a public spanking.
When
the
you're
only
wrong.
thing that's better is you have to retract it an hour later because you misunderstood what the hell you were doing. Because that could actually probably maybe, I don't know, Jemima, could that be a problem if she sanctions Alan Jackson on the spot and it shows there was nothing to sanction because he didn't do anything improper, she just misunderstood the evidence?
I think she could just retract it, right?
Yeah, but that would show her biases again.
Would it though? She misunderstood the situation and believed one thing, and it turned out.
Of course, Grant. I always
Grant's
go
such
to
an idiot.
with his track record.
Grant doesn't understand
Let's be fair.
social cues.
Any woman within a 4-foot radius of Grant looks nervous, right? They look worried every
And
time,
especially
every
worried.
single one.
I think it has to do with the certain odor coming off of his bidet. So whenever he claims that someone looks some way, it's normally always the total opposite side. Remember when he was at Aiden and fake victims last hearing, and he was, everyone was standing up, celebrating, clapping because she did so well. Yeah, that didn't really happen. But I don't know. This was a weird ending to a day that.
I can't wait till next week. I'll tell you that much.
Yeah, what?
The 26th, I think you said.
Oh, I muted just in time. That was a loud one. Sneeze.
Did you fart?
No.
Don't fart on camera.
Did not fart. Everybody saw me sneeze. I couldn't get the cam.
Yeah,
and
I do the same every time I had to fart. I always do that.
Sometimes I fart or I sneeze so hard I fart. That happens. Oops.
Sometimes you sneeze so hard you stress pee a little bit. It happens.
Hey,
Sometimes
things happen when you turn 40 years old, y'all. Things
Sometimes
happen.
when you sneeze, you pee. If you're a woman and have had children.
Hey, 2025, we don't see genders and colors, so we stress pee as well.
Well,
Goodness. Was it the 25th or the 26th?
25th, 11 a.m. Eastern, says Tosh.
Oh, that's right. That's right.
Didn't they change it like 3 times?
I don't know. Alan Jackson wanted to move it to the 26th, and she was like, you can be on Zoom. I remember that part.
Steve Fenner, what were you talking about? Somebody filed a habeas corpus?
What?
Did you say
Isn't that
habeas?
bringing a prisoner out?
Habeas corpus, that's right to your own body. Isn't that something if you're in prison? Chatham and Little say, can we just file a habeas petition? Well, Marissa, you can check, is anything on the docket?
Yeah.
What's a habeas? Hey, Brandon, haven't seen you in a couple of days. Hope you're doing better. But this has been a whole roller coaster of everything.
A habeas petition is when they say somebody's been imprisoned unlawfully.
Yeah, but she's not in prison.
She was.
She was.
And she's still on bail.
Yeah, I know. I think it actually in Latin means right to your own body.
Yeah.
But it means that you file a motion to be let out of prison. It's an old English law that is used.
The only new thing after what I sent you this morning is event result motion hearing scheduled on 12/18, held as scheduled.
Yeah, and if she did file a habeas, it wasn't something they wrote up in court today. So again, today will be filled with everyone who will tell you what to think, what to believe, what to see.
Just wait till next week, yo.
Let's wait. It's filed with the feds.
Yeah, she just sent you something on Discord. You might not be able to see
she
it.
sends me all the stuff. Okay, but that has also been presented before today because this is from 1:41 p.m. So that's, well, it's the journalist would have had this on the books and then presented it. Let's do this. Karen Reed has taken her double jeopardy challenge to toss the murder charges against her to federal court, filing a habeas corpus claim with the U.S. District Court in Boston. Federal filing comes on the same day she's in Norfolk Superior Court in a motion hearing. Instead, the hearing ended suddenly and dramatically with Bev saying that the prosecution's presentation on behavior with witnesses in the last trial profoundly affects the defense team. That's not what she stated. The sides will reconvene February 11 at 25th on 11. Reed is charged with second degree. In the federal filing, Reed is asking the court to issue a writ of habeas corpus and rule that Ms. Reed's re-prosecution on counts 1 and 3 would violate her double jeopardy rights. I'm claiming that my April 2025 retrial violates my federal double jeopardy rights. Reed has filed a petition against Norfolk Superior Court and the Massachusetts Attorney General. This comes after the Massachusetts Supreme Court issued a decision last week finding that Reed, pending retrial on the charges, did not violate her rights against double jeopardy. Reed's attorney have been arguing that several jurors reached out after last year's mistrial to say they were only hung on count 2, which is the OUY manslaughter charge, and were ready to acquit on the other charges. They say that no other juror has disputed this claim, and that to continue to try on these charges would be double jeopardy. Re-prosecution is barred because there was no manifest necessity to declare mistrial on counts on which the jury was not deadlocked. The jury unanimous conclusion following trial that Ms. Reed is not guilty constitutes an acquittal and precludes re-prosecution, the petition states. Both the Massachusetts trial court and Norfolk's DA's office declined to comment. Then we have the motion hearing. Nothing new there. So, they claim that conduct from the first trial influences the defense.
I can't wait till next week.
Yeah.
Yeah. No, Bev wouldn't stop it today. No, this has to do with what she saw. She claimed that it was because what she was shown by the state. But I still believe she misunderstood who had given it to Hank Brennan.
I agree.
If that's the case, that should get cleared up and be completely irrelevant by next week.
But and Bev doesn't do anything from the bench, so she had to stop everything because she has to get her minions to do all of her work for her. Which is why she doesn't rule from the bench.
I don't think she has the capability to do it because she doesn't even know what motions are filed in the case. So, I don't put much on it. But I'm gonna jump off, do some dinner, and then I'll be back in 45 minutes. Then we're gonna go back and watch whatever defense was put on in the Zachary Hughes case and see if they have a defense to put on.
Yes.
And we will keep an eye on everything. Marissa is my new go-to harass people, so they might want to talk to me on trial. Maybe if we can find someone who can come on and talk to us, I can force Marissa to send papers. I have to send it to Jamie to make Marissa do stuff, but that's my big trouble.
The bureaucracy.
Marissa is willing, but Jamie, she's on vacation. I'm gonna have meatballs, so in Danish.
Let me see if I can redirect real quick.
I'm redirecting you all over to the stream I'm coming up with in 45 minutes.
Let me add that to my redirect.
And hopefully, let's wait till next week to lose our mind. And remember, whatever you read right now is BS. No one knows any more than you do because you watched it. We watched it 3 times. No one knows what's going on.
There you go. My chat, I've got you set up to go over to Baker's as well.
So I'll jump off, go make myself dinner, come back on, and we'll figure out how Zachary Hughes defended himself. It's been a long day, been a busy day. It's going to be even longer tonight.
Yeah, you're not done yet. What are you talking about?
No, I'm saying it's going to be an even longer tonight because it's 8 o'clock. See you later, Valhalla.
Right. See ya. Love you, buddy.
You, brother. Thank you for
love you so
here.
much.
Yeah, Marissa, love you. Listen, thank you. Thank you for having
love
me.
you guys.
Yeah. Chat, I love you.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Checking your honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.